Welcome to the Bar Exam Toolbox podcast. Today we are talking with MBE expert Sean Silverman and walking through and discussing actual MBE questions together. Your Bar Exam Toolbox hosts are Alison Monahan and Lee Burgess. That's me. We're here to demystify the bar exam experience so you can study effectively, stay sane, and hopefully pass and move on with your life. We're the co-creators of the Law School Toolbox, the Bar Exam Toolbox, and the career-related website Career Dicta. Alison also runs the Girls Guide to Law School. If you enjoy the show, please leave a review on your favorite listening app and check out our sister podcast, the Law School Toolbox Podcast. If you have any questions, don't hesitate to reach out to us. You can reach us via the contact form on barexamtoolbox.com, and we'd love to hear from you. And with that, let's get started. Welcome back. Today we are chatting with MBE expert Sean Silverman, who will be walking us through some MBE questions. Super exciting, right? Sean is an MBE expert who also tutors folks for the MBE and the Florida and UBE bar exams. So for those who don't know, or might be new to the bar exam, the MBE or multi-state bar exam is a 200-question multiple choice exam that takes place on the second day of the bar exam in almost every state, right, Sean? And now it's every state is it the second day, I think.
I believe so.
Yeah. New Jersey used to be different, but now I think they're the UBE, so I think it's everybody. It is unlimited fun or not. I don't know. Depends on who you ask. For many folks, this is the most challenging part of the exam. It was for me, for sure. So today, Sean and I are planning to walk through some MBE questions and discuss what makes them hard and how you can get better at doing these questions with deliberate practice and a plan of attack. I will be honest, preparing for this podcast was not my favorite episode to prepare for because I found myself starting to fall for some MBE tricks if I don't read the questions carefully enough. It's so embarrassing to admit after all these years. We are going to walk through some released questions from the National Conference of Bar Examiners, who actually writes the MBE. We're going to link to a PDF in the show notes where you can find these questions if you want to read along while listening to the podcast or review afterwards. All right, Sean, so thanks for joining us to chat about the MBE.
Thanks for having me back.
I think you're one of the few people who I can send an email to and say, hey, do you want to talk about some multiple choice questions for me on the podcast? And you're like, that sounds great.
I was thinking the same thing. I'm guessing there probably aren't too many people who would want to do this as opposed to have to do it. But
exactly.
We're among them, so.
Exactly. All right, so let's start with question number 1 on the released questions. So I'll go ahead and read the question, and then you and I can kind of talk about how you go about getting to the right answer.
Okay.
A father lived with his son who was an alcoholic. When drunk, the son often became violent and physically abused by his father. As a result, the father always lived in fear. One night, the father heard his son on the front stoop making loud, obscene remarks. The father was certain that his son was drunk and was terrified that he would be physically beaten again. In his fear, he bolted the front door and took out a revolver. When the son discovered that the door was bolted, he kicked it down. As the son burst through the front door, his father shot him 4 times in the chest, killing him. In fact, the son was not under the influence of alcohol or any drug and did not intend to harm his father. At trial, the father presented the above facts and asked the judge to instruct the jury on self-defense. How should the judge instruct the jury with respect to self-defense? So like all MBE questions, there are 4 options. Mm-hmm. So option A, give the self-defense instruction because it expresses the defense's theory of the case. Option B, give the self-defense instruction because the evidence is sufficient to raise the defense. Option C, deny the self-defense instruction because the father was not in imminent danger from his son. And D, deny the self-defense instruction because the father used excessive force. Whew, that was a lot of words for some options. I guess these aren't designed to be read aloud like a narrative. But so, Jean, let's say this is number 1 in your packet. So, what's the first thing you do when you get to an MBE question, other than read it? Right.
So, and I think that this part really differs because I even, students will talk to me about maybe they've been tutored by other tutors and so forth, and different tutors come about in different ways. But I tend to recommend reading the question first. I'm wondering if you do the same, Lee, or because it is sort of a very, I think, personal thing for for tutors how they go about answering questions.
Read the entire question or just the call?
Like the call of the question to kind of get a feel for what it is that we're going to need to do. Do you do that or?
So personally, I don't, but I've had students who that really benefits. I do think it's something that you have to try both ways. I think for me personally, I've always liked the story first, and I find that the answer choices can cloud my version of reading the facts. Because maybe I get caught up on one of these options and then I'm looking for the facts instead of just reading the facts for what they are.
Yeah.
But I've definitely had a lot of students who need that grounding, kind of stake in the ground of, okay, this is about a jury instruction. This is about self-defense, and going back and reading the facts with that in mind. So I think for our listeners, if you've never tried it both ways, I think it makes sense to see if your accuracy changes when you do read the call of the question first or whether you read the facts first.
And I agree with that. And I don't actually recommend reading the answer choices.
Oh, okay.
You know? Yeah. I think that I do know that is something that is recommended. So I think there's just a lot of different things that people do. I don't like the idea of reading the answer choices. What I would tell a student is just that question where it says, how should the judge instruct the jury with respect to self-defense? Sort of before reading the facts.
Mm-hmm.
The reason for that is, well, I'd say two. One is keep in mind the questions are all jumbled together. I think a lot of times when people practice for the test, they might do 40 contracts questions, and then maybe another day they'll do property questions. But then the day they take it, they're all mixed up and jumbled together.
Yeah.
And so if I read the question, the first thing is now we know what subject we're in, hopefully. Not always.
Right.
Sometimes it's pretty vague, but we'll probably know what subject we're in. And I think that alone helps to know that. And more importantly, though, it's like we kind of have an idea of what we're looking for when we read the facts. I don't like the idea of reading the facts and trying to figure out what it is I'll later be questioned on.
Yeah.
As opposed to kind of like knowing ahead of time what it is I'm going to have to do at the end and trying to figure it out as I read.
That's a very good point. And it allows you to look for those legally significant facts, because just by reading the prompt here of how should the judge instruct the jury with respect to self-defense, when you read the facts, you can say to yourself, okay, I'm looking for legally significant facts about self-defense.
Exactly. And it's just, it gets a little bit more difficult in my mind to read it without knowing where I'm sort of headed. But then, just with that said, occasionally I will have students tell me that if they read the question first, they're just thinking about that instead of focusing on the facts, and that's the risk.
Yeah.
And so I think it's just a matter of, like you said, trying both, seeing which one works better.
Yeah.
For this one, the father presented the above facts and asked the judge to instruct on self-defense. So if I had read that first, I would be reading the facts and, knowing the elements of self-defense, knowing what they're asking about, trying to figure out if those elements have been satisfied. That's what I would be as I read it.
And I think one of the things that oftentimes students forget about multiple choice, unlike the essays, is, because the answer is on the page, I think sometimes people forget that you need to then recall all the elements of self-defense and what is necessary and apply it to these facts. It's similar steps to what you would do if you were writing out a short answer.
Mm-hmm. Exactly.
Because sometimes I think they just go in and they're like, right, self-defense. Yeah, I kind of know what that is. And then you start reading the facts.
Right. And I mean, even that, at least it's self-defense, right? I mean, there's just so many different things that could be tested. And at that point, knowing it's self-defense, knowing what I'm looking for, as I read the facts, it looks to me from listening to you read the facts and from reading them that there could be a self-defense argument here.
Right.
Now, what struck me was sort of the last line, I think. Let's see. Is in fact, the son was not under the influence of alcohol or any drug and did not intend to harm the father. Just, they're just tossing that in at the very end.
Yeah.
Right. But not really to help.
Right.
Notice. Right. Like that line is sort of there to take you away from the right answer a little
bit. Right. Because
right?
That made me think of imperfect self-defense or other issues that could come up because he wasn't actually under the influence of alcohol. Or it made me think of Yeah, it made me think of lots of different things other than what I
Right.
need to be thinking about for this
And it's at
individual
the
question.
very end. It's at the very end, so it's the last thing that you're going to be thinking about when you go to the answers. So actually, I mean, sometimes I do notice that I'm a little too cynical after doing this test for so long. But
Hmm.
I think if they're not going to give you such a helpful line at the very end, they probably throw it somewhere in the middle, right in the
Right.
center. You might miss it. So if they're telling me that at the very end, I'm going to be a little bit skeptical about it, like because they're trying to make me think that he did not intend to harm the father. Okay.
Right.
Well, if somebody doesn't intend to harm me, but I have every reason to believe that they do, I can still use self-defense,
Right.
even if they don't intend to harm me. So, but of course, one of the wrong answer choices could be no, it's not self-defense because he didn't intend to harm,
Right.
something like that.
Right.
So with that said, how do you go about the answers? Do you run down them and read all four sort of before you pick one, or if you see one you like, do you pick it? Because I know it's such a time constraint that
Yeah.
I sometimes don't. I don't. I think it depends sometimes. Like if I see something that I really like, and I'm very sure that it's correct, I could just pick it. But my general approach is to read all four.
Yeah, I think that's my general one as well, unless I'm worried about maybe I skim them and I'm like, oof, I can't decide. They're too close. So sometimes what I do is I just ignore the answer choices and ask myself what would be my answer if this was a short answer. That's probably because I'm much better on essay questions than I am on multiple choice questions. And so then I might say to myself, okay, can he get self-defense? I apply the law to self-defense. It's about his reasonable, fear.
Right.
And then I think, okay, then yes, I think he does
Hmm.
have a reason to get that self-defense
Hmm.
instruction. And then maybe I go back to the answer choices and kind of parse through them. But that way I don't get so sucked in by some of the quality answer choices that are made to sound wrong. Or they're made to sound right, but they are wrong.
Yeah, like the
The
distractors. I mean,
distractors. Yeah.
yeah. So I would do the same, and if I do think it's self defense, I might still look at the other two, and
Yeah.
the two that go against what I'm thinking, and just let me just confirm, right? And
Right.
and most likely, once you have a feeling of which way it should go, the two that are wrong, it shouldn't be that. It's rare that they're going to pull you back.
Got it.
Like if you think it's A or B in this case, chances are C and D won't sort of pull you back, but it is good to confirm it. So, like for example, C denies self-defense because the father was not in imminent danger. I mean, there's that last line that they threw in, right?
Right.
We just have to know a little bit about self-defense to know that that's not true, right? So we can call that like a mistake of law. There's different ways to categorize these wrong answers, but C is wrong. And then D, deny the self-defense instruction because the father used excessive force. Well, it's sort of like a judgment call first,
Right.
right? Did he use excessive force? Did he not? They seem to be implying that he definitely did use excessive force. But if he believed his life was in danger, then I don't know what is excessive there.
Right.
I mean, I
Yeah.
think you can kill, so I don't know what would be more excessive than that. So neither of those seem right. I think in this question, A and B are pretty tricky, though. Actually,
Yeah.
it's like a little bit procedural, more.
Mm-hmm.
A says give the self-defense instruction because it expresses the defense's theory of the case, or B says give it because the evidence is sufficient to raise the defense. What were you thinking about those two? I thought it was kind of hard.
Yeah, I thought it was tricky too. I think what's interesting is with A, they say because it expresses the defense's theory of the case.
Mhm.
Just because the defense has a theory doesn't mean that it's legally correct to get a
Right.
jury instruction. But I think that my initial thought was, well, that's a pretty good answer because clearly they're going to argue self-defense because of all
Hmm.
these facts of fear.
Hmm.
And so I thought A and B really made you kind of think about which one was the better answer, which is why this test just drives me absolutely bonkers, is because because A is kind of right, sort
Yeah.
of,
Yeah.
but B is more right. I guess I just let the cat out of the bag, but B is the right answer. But
Yeah.
I think that's where it becomes really tricky, and that's why you have to practice and be so methodical about these.
Right. And I think this test, it's not the LSAT, right? But it is a
Right.
test. It is a test of logic in a sense, and I think that's more about what the difference between A and B might be, more about logic than knowing the law of self-defense. Because, as you were saying, it says because it expresses the defense's theory of the case in A, and that does seem to imply that even if the evidence wasn't sufficient to raise the defense, then they would still be able to.
Right.
Because they seem to be saying all we need to know is that it expresses the defense's theory of the case. But then we have like this other qualification in B, which seems relevant. That's the way I would probably tell students. I think this is a pretty tough question, but how to distinguish between A and B would be to ask whether or not the new qualification they put into B was relevant. And it seems to be. It's sufficient to raise the defense. I mean, so if it weren't, let's say that they threw in some irrelevant qualification after the word because in B, then I think A might be the better answer there. So
yeah, and I think it's also interesting that they are asking about a jury instruction here and not about whether or not the defendant can raise self-defense at all. You know, because I could see it being, you know, if you're thinking about it and saying like, well, can he raise self-defense as a defense in court? I think the answer could be like, sure, because that's their theory of the case. But, you know, we're asking about a jury instruction. So we're at the end of the trial, and now the judge is deciding what to ask the jury. And so I think that's another tip, that it's more about evidence. It's a decision based on what was presented at trial and not just, you know, the theories of the case.
Right. And they gave us enough facts, if we were to look back at the facts, to indicate that there was at the very least potentially self-defense here.
Right.
You know, and so the jury should consider it.
Yeah.
But not merely because the defense believes they should, which I think is what A kind of says.
Yeah.
Like, you know, the defense thinks that self-defense is valid, therefore the jury should hear about it. Whereas B says, well, enough evidence has been presented whereby the jury should hear about it. So it's a little bit of a better answer, but I was definitely looking at those two.
Yeah.
And what I tell students is when you're down to two, I mean, that is ultimately the goal, the first goal. Unfortunately, sometimes, maybe you've heard this, you know, students will come out of the test and say they got it down to 2 on every question.
Right.
You know, and like that means maybe they did excellent on the test, or maybe they got everyone wrong. They don't know because they got it down to 2.
Yeah.
So ultimately, we do want to get it down to 1. But I think the first goal is to get it down to 2, and then kind of look for the one that's worse. That's what I've learned over time with this test, is if I'm down to 2, I'm actually trying to find something wrong with one of them.
That's
as
good.
Opposed because maybe I think you had mentioned it earlier that there may not be a perfect answer. So if we're looking for it, we might not find it, but we'll find something wrong with one of them.
That's true. And as my father told me the morning of the MBE, at least the answer is on the page. You do know
it
that.
Is. Yeah.
I was like,
just a little hard to find.
It can be hard to find. I was like, thanks, Dad. My dad, my parents are both lawyers, so they have lots of advice.
He took the test?
Yes.
At some point? Okay.
At some point, yeah. A few moons ago. Let's just put it that way.
Yeah.
I don't think he listens to the podcast on a regular basis, so I won't out him for how many years he's practiced law. But
yeah.
All right. Okay. Well, let's go on to, this is number 2 in the on the PDF of release questions. A man sued a railroad for personal injuries suffered when his car was struck by a train at an unguarded crossing. A major issue is whether the train sounded its whistle before arriving at the crossing. The railroad has offered the testimony of a resident who has lived near the crossing for 15 years. Although she was not present on the occasion in question, she will testify that whenever she is home, the train always sounds its whistle before arriving at the crossing. Is the resident's testimony admissible? So starting with what you mentioned before, if you do read kind of the call of the question, is the resident's testimony admissible? That at least tells us that we're in the evidence realm.
Right. Agreed. Yeah. And that's, of course, scary for many people.
Right.
People find that subject to be, you know, maybe the toughest one on the test. But, you know, certainly that's the only subject where they're going to ask that.
Yeah.
You know, is the testimony admissible? It doesn't really help other than that, right? I mean, there are some questions that actually clue you in to what issue you should be searching for. You know, for this one, we will be looking to see if the evidence is admissible. But other than that, it would be tough to know, you know, what exactly to look for.
Yeah. So it's a short fact pattern, but a very open-ended call.
It is.
Yeah.
It is. And as I'm reading it, you know, habit evidence does come to mind. I think, as you were reading it, is that something that you would have thought of? I think it's a little subtle though, because
personal knowledge was the first thing that came to mind, was that there's a problem because she wasn't there the day that the accident happened.
Right.
So that was as I was reading the facts, that was the first thing that kind of popped into my mind, was that could be a problem about her testimony.
Mhm.
But then I think then the question becomes, okay, well, if she didn't have personal knowledge of the day, then is this evidence of value at all? So you got to
Right.
find a different kind of bucket it could fall into.
Hmm. Exactly. And I would think perhaps, the only way to get this in might be have it,
Yeah.
right? And then I look for some keywords. She will testify that that word always is kind of important in
Yeah.
that last line. The train always sounds its whistle. So they seem to, I've noticed in the questions a lot of times, it's like if somebody does something often but not always, it might not satisfy the habit requirement. But
Mm,
they're putting that word in there for a reason.
yeah.
Um, so would you have been thinking no or yes on this one?
So I think I would have started leaning towards yes once I realized that there were other ways that she could get this in other than just the fact that she didn't have personal knowledge of the day. So once I was like, well, this could be a habit or something that could come in a different way than just her saying like, on this day, November 12th, I was not home, but I'm sure
Hmm.
they did it. I think that one of the things that is important to think about, especially with evidence, is if you can't remember all of the rules, and I'll be honest, I know a lot of evidence rule, but if you asked me to recite the habit rule from memory, I couldn't. I mean, I know there's a habit rule. I always go back to this idea that they're really worried about reliability
Hmm.
and whether or not somebody could be fabricating something or that there are other kind of details that make someone's testimony unreliable. So that's why you have to have personal knowledge, because if you were there, it's likely that you are a bit more reliable, or the rules like present sense impression or excited utterance and things like that. So I think one of the things I always go back to, if I can't remember exactly the rule, is would this seem reliable? She lived there for 15 years and she says that they always
Right.
sound,
Mm.
the whistle. That sounds
Yeah.
pretty reliable to me.
Yeah. So like the policy, and that's I say that all the time. Sometimes if we can understand why we have the rules, we won't have to memorize them as much.
Right.
So, but as you can see in choice A, personal knowledge is right there for you. You know what I
Right.
mean? Like if they have an idea of what wrong answer you might have in your mind,
Right.
and so
Are they
would you have?
listening to my brain? Are they like, it's like, are they watching me while I read these questions?
I wouldn't hold it against them, but would you have been tempted at all by A, or would you have been sort of thinking it's probably not that?
I think that if I was under strict time conditions, I think A could have been a sexy answer for me,
Yeah.
because I saw personal knowledge, and personal knowledge was one of the first things that came to my mind. And so I think that's where slowing down and forcing yourself to be methodical through these questions is so important. And I see this with my students a ton, is they go quickly. And when they see the first answer question that hits terms of art that they had in their head, they assume that that's the right answer. And this test is just too hard for that.
Yeah. And I would say what I would do with A is it's not the kind of answer that, for all we know, it could be right. That's the thing. It depends upon what else they've given us. You see,
Right.
so I might actually hold on to it. I might not be so quick to cross A out. I'm really looking to cross things out. That's my goal with the test. So
Yeah.
I'm sure I'll be able to cross out at least one or two of the four, but it might not be A. And so with B, no, because habit evidence is limited to the conduct. That's kind of an interesting one, in the sense that it seems like it always has applied to persons in just about every other question,
Right.
right? And they're playing off that a little bit, I think. But just because it always has applied to persons and not businesses doesn't mean it can't apply to businesses. And maybe we can even fit this into. I mean, we're talking about the railroad, but somebody is controlling it, right?
Right.
And so I don't even know that B makes all that much sense if you think about it, because it still is a person doing an act.
Yeah. And I mean, if you've studied for the bar and you've been studying for a long time and you've never heard of that rule,
Right. That's true.
that's one of those where it's like, really, are they testing on a nuance that
Right.
nobody's
But,
ever really heard of?
yeah. And they do that, though.
Well, that's true. They do that. Fair point. Sorry, guys.
Yeah. I think of A and B might be easier to cross out. That's the thing. And I've got to cross out some things,
Right.
So C, just notice how they don't use the word have it in C.
Yeah.
The the one thing is the right answers are often couched in language that is a little more subtle, whereas the wrong answer in B is perfectly fine using that word, right? But this is going to kind of like make you figure out that routine practice means habit.
Yeah.
And then D, yes, as a summary of her, buzzwords, I think we call those, present sense impression is something in evidence law.
Yeah.
And, believe it or not, that can make it a tempting answer. When you stuff this amount of knowledge in your head, you see present sense impression, you're like, yeah, I read about that.
Right.
That's something that was in my outline. But it doesn't really apply because we're not, that's an exception to hearsay and all that. And it doesn't really fit here. So I think D could be crossed out. At that point, we get it down to 2. The reason for using that approach is let's just assume we liked A and picked it, which is definitely something we do, I think, especially as the test goes on.
Yeah.
Sometimes I think of this test as like a marathon, and by the last 20 questions or so, you might not be doing everything you did on question 1.
Right.
Maybe you're not crossing everything out and doing everything you were doing at question 1, so you're just trying to get through the thing. And if that's the case, we might pick A. But if we read all 4, we might actually not realize that A is not right till we read C. So once we read C, that would clue us in that we forgot to think about habit.
Right.
I thought personal knowledge was what was required, but now we'll think about habit. Then at least we'll be able to figure out, is habit a better answer here than personal knowledge? And it seems like it would be, and it turns out it is.
Yeah, because actually they also say that they've offered the testimony that when she's home, the testimony isn't about the day. The testimony is about what happened over the 15 years. And so, I think that's, if you've got to go back to the facts, sometimes when I also get it down to 2, I go back to the facts and I can say, like, what are they giving me in those facts? They're giving me more facts about something. They don't give me very many facts about her personal knowledge, but they give me more facts about the fact that she always hears the train whistle.
That's true. And I think this just comes, we've been around the test a while,
Yeah.
And I think all these things we're doing is tough to do when you're first learning the law. And so that's why you want to get to this point. You might not be doing it to the extent we're doing it, but it will get you better at this test if you start using strategies like you're talking about.
Yeah.
And so half the battle is knowing the law, but the other half is kind of using these kind of strategies that we're talking about.
And slowing down. I think that speeding through these questions is really such an easy way to trip yourself up. And I find especially, I don't know if you see this in your practice too, Sean, but there's so many more people who are studying and working these days. And, when you're doing these late at night, especially, I have so many people who study MBE questions, at 10 o'clock at night, which, you're tired. I was prepping for this podcast at 7:30 last night. And I was like, whoa, I'm going cross-eyed. So, so I think that you have to be really thoughtful about when you study for this, because exhausted, unfocused study is just going to lead you down the wrong road, and you're not going to be able to catch these tricks as presented to you.
So true. And then there's the balance, right? Because I always forget the exact amount, but I think it's like 1.8 minutes per question, something like that.
Yeah.
So you don't want to go too fast, and you want to be careful about not going too slow, right?
Yeah.
And so it's it comes with practice. There's also quite a lot of strategies, of course, about when to skip a question and things like that.
Right.
Probably tough for us to get into everything, but certainly if you come to a question, and there can be times, because when I took it, it happened, and there can be times when you're just reading the facts and you just don't know what's going on. Like it's you're completely lost. It's better to probably take the hit on that question and just move right along. If you spend 3 minutes on it, let's just say maybe a little more than 3 minutes, we'll say twice the amount of time you're supposed to spend on a question. Well, one possibility is you get it right. Okay.
Right.
But you're not going to probably get to some question at the end now. And so that one's, unless you happen to guess right, that one's going to be wrong. So it's all going to even out. Or you'll get the one wrong that you spent 3 minutes on, and then you'll get that later one wrong. Yeah. So it's better sometimes to just say, I'm going to pick a letter and move right along if that happens.
Yeah, because it's a point collection game.
Yeah, exactly.
And if you have never gotten the rule against perpetuities right ever in your life, then maybe you shouldn't spend a lot of time struggling with those questions.
Right.
You know?
And they continue to test it.
They do, because they love it, because it's
Yeah.
so exciting. That and prior bad acts and mortgages.
Oh, yeah.
Yeah. All right, let's move on to our next question, which is number 4 on the PDF. A man has 4 German Shepherd dogs that he has trained for guard duty and that he holds for breeding purposes. The man has, quote, "Beware of dogs" signs clearly posted around a fenced-in yard where he keeps the dogs. The man's next-door neighbor frequently walks past the man's house and knows about the dog's ferocity. One summer day, the neighbor entered the man's fenced-in yard to retrieve a snow shovel that the man had borrowed during this past winter. The neighbor was attacked by one of the dogs and was severely injured. In a suit against the man, is the neighbor likely to prevail? And our options are no, because the neighbor knew that the man had dangerous dogs in the backyard. 2, no, because the neighbor was trespassing when he entered the man's property. Yes is option C. Yes, because the neighbor was an invitee for the purpose of retrieving the shovel. And D, yes, because the man was engaged in an abnormally dangerous activity. Okay. Oh, mean dogs. They always seem to show up.
They're on every test. But so I think the first question is like maybe whenever I see somebody going on land, I'm trying to figure out what's their status. You know, are they a licensee? Are they an invitee? And then of course they try to play into that in choice C there.
Right.
But I don't see why he wouldn't be a trespasser here. Were you having the same thought? I mean, he was.
I was too.
I mean, I guess they do tell us. Let's see, that he did it often. Did they tell us that, or did he?
No, I think they just said that they just like one day in the middle of summer, he just decided to get his snow shovel, which I thought was super weird.
Right, and doesn't seem to care about the sign, right? Or maybe either didn't see it or doesn't seem to care about it. But it says clearly posted, so I'm assuming he probably saw it.
Yeah.
Right? And then he goes on there, but yeah, he does seem like a trespasser to me. So that I'm just saying that would be step 1. Yeah. And then there's those rules about trespassers that we have to deal with, right?
Right.
So, some trespassers, about them. Maybe they first of all, they come on all the time and you don't seem to mind, I guess.
Yeah.
But they're still trespassing. So they're just known trespassers and they have more rights than people who you don't know about. So that's why I was wondering if he knew about this person, but it doesn't look like he did, I guess.
It doesn't sound like he invited him on, I guess he knew that he had his snow shovel, but it's not,
right.
There's no facts about the fact that he asked if he could come get the snow shovel or that they always had an agreement that he could pop into his backyard. I mean, if I found my neighbor in my backyard, I'd be like, what are you doing in my backyard? Even though I don't have ferocious dogs in my backyard.
Yeah. Yeah. And so I think it would have been a tougher question. I mean, it's interesting to think about how it might have turned out. Let's say he was a discovered trespasser.
Right.
He's the kind of trespasser that you've seen, come on your property numerous times in the past.
Right.
But you don't allow them to come on. So they're still trespassers. Even so, I think even in that situation, I think that there would be a tough case for him. Because if I'm correct about this, I think these discovered trespassers, they can only recover if it's something that some kind of artificial condition that might kill them or something like that.
It's pretty extreme. I mean, because if you have somebody who makes a bad choice, and so you can tell I have a small child, it's all about choices, good choices and bad choices. But if they make a bad choice and say, I'm going to go in where I know there are ferocious dogs to get my snow shovel. Going back to, we were talking about policy with one of the evidence questions. It's kind of like, do we think they get to recover because they chose without permission to go into your backyard where they know you have ferocious animals?
Right. I mean, it almost sounds like an assumption of risk argument you're making.
That's true.
And I was looking for it when I did the question. They don't seem to be going there. I guess because that's more of a defense, and if there's no liability, there's no need for a defense.
Yeah.
And
true.
But assumption of risk, it certainly seems like it could be.
Yeah.
You assume that risk when you enter. And so I would be led, it says in a suit against the man, is the neighbor likely to prevail? because he was a non-discovered trespasser, I would be very heavily leaning towards no.
Mm-hmm.
I think it's an even easier case than if he were discovered. Now they say no because the neighbor knew that the man had dangerous dogs in the yard. So they don't give answer explanations, right? They only give the answers to these questions.
Right.
But I would think they might be playing off assumption of risk a little bit there,
Yeah.
or perhaps they're just saying if he knew about it, then it's not one of these hidden dangers that maybe he could have recovered for.
Right.
That's possible. Something like that. Either way, it's looking pretty good. However we get there.
And they gave us a lot of facts about that, right?
Right.
He's got beware of dog signs. The neighbor frequently walks past his house and knows about the dog's ferocity. So they have like multiple sentences of knowledge and warning, I guess.
True. B, no, because the neighbor was trespassing when he entered the property. So what do you think about that one? In other words, why is that wrong?
Well, I mean, I don't think it's completely wrong, but it's definitely incomplete because of what we were just talking about. Like, I think there are situations where a trespasser can still recover. Okay. So
that makes sense.
So even if he was a trespasser, and that's one of the reasons why he can't recover, right. I don't know that really does it for me, although I probably wouldn't completely cross it out. This is where I sometimes find myself going back to the facts and saying, okay, well, do we have a lot of facts about him being a trespasser? Or do we have a lot of facts about something else? And here we have a lot of facts about his knowledge about the dogs. And so if I had to guess which way it was going to tip towards, I'm like, well, they gave me facts about knowledge of the dogs. That's probably what's most legally significant here.
Right. And I think I think what you said about B, you can be a trespasser and still recover.
Right.
That makes B look really worse than I thought when I first read it.
Yeah.
Because you can be a trespasser and still recover, and it says no because he was a trespasser.
Right.
I mean, sometimes it's as simple as just the fact that it's logically wrong to say no because he was a trespasser when trespassers can recover.
Yeah.
makes B just wrong.
Yeah.
Right? From logical. And then C, yes, because the neighbor was an invitee. That would be an easier one to get rid of, as long as we just know how to sort of satisfy these standards. I don't think he fits that definition of an invitee.
They didn't give us enough facts about it.
Right.
Yeah.
Right. And he just goes on the property, as a trespasser. So C to me is pretty easy to cross out. And then D, yes, because the man was engaged in an abnormally dangerous activity. Those are buzzwords again. Yeah. I think, like we said before.
Yeah.
They like to do that. I think you just have to know where those words are used. We often see that with strict liability, but a very specific type. Mm-hmm. And by the way, almost always with explosives, if you've noticed, somebody will be dealing with explosives or something, and they'll try to keep it as safe as they can, but they'll injure somebody, and you're still liable because you're strictly liable for an abnormally dangerous activity. So it doesn't really fit in this fact pattern as far as I can tell. So that's how I would do this question. I would get rid of them. I think we had A and B as the two contenders here, but we were able to get rid of B. So
yeah, I think that makes a lot of sense. And I think it's interesting about the abnormally dangerous activity because it makes me think about the question we just did where the last option had that present sense impression language that again didn't really apply, but wanted to send you down that road of hearsay exceptions.
Sure. And they're just playing off the difficulty of this test. It's like so much information you've stuffed into your head. It's almost psychology, I think. Just seeing something that you recognize is going to make it tempting, whether it's right or wrong.
Right.
And those words are definitely words that are going to be right in other contexts.
Right. Because you have a line in your outline that says abnormally dangerous activities, strict liability.
Mm-hmm.
So
yeah, they've got tricks. They've got a lot of tricks, as you can tell.
They do have a lot of tricks. Okay, I think that one was a great question to go through. And I think the last thing I would mention is if you go back through this question and you're reviewing it, I think the fact that the right answer choice does not include any terms of art is just so interesting to notice. Because option B includes the word trespassing, option C includes invitee, and option D includes abnormally dangerous activity. But the right answer does not have any of those buzzwords.
That's a great point. I think that That's something I've noticed is that the right answer is like hidden, and the wrong answers are kind of like in your face.
Yeah. Yeah.
You know, so just another strategy or trick to use when you're doing this.
Yeah. And with that, we're out of time. I want to take a second to remind you to check out our blog at barexamtoolbox.com, which is full of helpful tips to help you prepare and stay sane as you study for the bar exam. You can also find information on our website about our courses, tools, and one-on-one tutoring programs to support you as you study for the UBE or California bar exam. If you enjoyed this episode of the Bar Exam Toolbox podcast, please take a second to leave a review and rating on your favorite listening app. We'd really appreciate it, and be sure to subscribe so you don't miss anything. If you are still in law school, you might also like to check out our popular Law School Toolbox podcast as well. If you have any questions or comments, please don't hesitate to reach out to myself or Alison at lee@barexamtoolbox.com or allison@barexamtoolbox.com, or you can always contact us via our website contact form at barexamtoolbox.com. Thanks for listening, and we'll talk soon.